thanks to all of you for joining us today for our webinar entitled What We Can Do to Rein in JUUL. As Brandon mentioned, my name is Mark Meaney, and I am the lead senior staff attorney for technical assistance here at the Public Health Law Center, and I'll be moderating today's webinar. As you may know, this is the second in a series of webinars that we have presented primarily on JUUL products. Our first one was in April, and that was focused on youth use of JUUL products and recent research into that area. And if you haven't seen it, it is archived on our website, and I encourage you to spend some time looking at it if it was very interesting and very well attended. Today, we're going to focus on regulatory options and opportunities at the federal, state, and local levels. Just for some background, JUUL, as you probably know, is a next or a current generation e-cigarette product that has become enormously popular with youth and young adults in a very short period of time. It resembles a flash drive, so it's easy to conceal, and it often has high levels of nicotine, so it's also extremely addictive. JUUL products currently dominate the e-cigarette market. They have what's estimated to be over a 60% market share, and according to an article I was reading just last night, the company is valued at around $15 billion, so it is very big business. That makes it a very important and timely topic for us to be discussing today. And we are delighted to have two national experts joining us for this webinar. Our first speaker today is going to be Dennis Henigan. Denny is the Vice President of Legal and Regulatory Affairs at the Campaign for Tobacco-Free Kids. He focuses on issues involving FDA regulation of the tobacco industry and related litigation, as well as providing legal guidance on federal, state, and local tobacco control legislation. Before joining the campaign in September 2012, he worked for over 2 decades at the Brady Center to Prevent Gun Violence, first as the director of the center's Legal Action Project, and then as the center's vice president. Before his tenure at the Brady Center, Denny was a partner in the law firm of Foley and Lardner. Denny is going to be talking about the role of the federal government, and specifically the FDA, in regulating these products. He'll discuss the scope of authority of the FDA and how that authority has and has not been exercised to date. After Denny, we're going to hear from Hudson Kingston. Hudson's a staff attorney here at the Public Health Law Center. He provides legal technical assistance on tobacco control issues around the country. Before joining the Public Health Law Center, Hudson worked as a public interest lawyer with a focus on environmental law, consumer protection, and government and corporate accountability at the White House Council on Environmental Quality, the Center for Food Safety, the Center for Digital Democracy, and the Minnesota Center for Environmental Advocacy. And in light of where we are at the federal level, Hudson's going to be talking about the wide range of state and local policy options for regulating electronic nicotine delivery systems, including JUUL products. This webinar is sponsored by the Tobacco Control Legal Consortium, which is a program of the Public Health Law Center. For those of you who aren't familiar with our organization, we are a nonprofit legal center located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. We work on a wide range of public health issues, from commercial tobacco control to healthy eating and active living policies. Our mission is to improve health through the power of law. We are committed to the principle that good public health cannot be achieved without addressing health equity, so we strive to approach all of our work through a health equity lens. Our bread and butter activity here at the Public Health Law Center is to provide free legal technical assistance, and we work with state health officials, local health officials, attorneys, advocates, and individuals in helping them to solve some of their problems. And that help, we provide help through legal research and analysis, through policy development, implementation, legal defense. We also have a wide range of publications on our website that I encourage you to check out. And then we do a lot of training such as this webinar. What we don't do is any direct client representation, although we do help, as I mentioned, legal defense, and that's primarily through the filing of amicus or friend of the court briefs in cases that have some national legal significance. And often we do that in close coordination with Denny and his team at the Campaign for Tobacco-Free Kids. We also don't do any direct lobbying. Well, a couple of housekeeping issues that I want to mention is, first of all, please, we're going to save some time for questions at the end, so please feel free to submit them at any time, and we will try to get to them at the very end of today's presentation. And then second, we have also applied for CLE credit for this webinar. So without further ado, I want to turn this over to Denny.
Mark, I really appreciate the opportunity to be part of this webinar and welcome everyone who is participating. I also want to thank TCLC for conducting this series of webinars on the emerging public health threat posed by JUUL. My focus today is going to be the connection between the emergence of JUUL as a public health issue and the exercise of FDA's regulatory authority. I'm going to talk about how FDA has responded to JUUL, and more importantly, how FDA's regulatory decision-making may well have contributed to the public health threat posed by JUUL. Okay, as you can see from this slide, FDA has expressed great concern about JUUL and the threat that it and other e-cigarettes pose to adolescents. In April of this year, the commissioner issued a statement recognizing what he called the troubling reality that e-cigarettes had become wildly popular with kids. And he noted products like JUUL and other brands that closely resemble a USB flash drive, have high levels of nicotine and emissions that are hard to see. He explained that these characteristics may facilitate youth use by making the products more attractive to children and teens. He said these products are also more difficult for parents and teachers to detect, and many of us have discovered that. And it also should be noted, although the commissioner didn't note it at the time, that JUUL comes in various sweet, kid-appealing flavors, including mango and creme brulee. Commissioner Gottlieb further noted that in some cases, our kids are trying these products and liking them without even knowing they contain nicotine, even though nicotine can rewire an adolescent's brain, leading to years of addiction. And Commissioner Gottlieb concluded the FDA must and will move quickly to reverse these disturbing trends, and in particular, address the surging youth uptake of JUUL and other products. Well, before we turn to what FDA is actually doing about JUUL, it's important to first consider how we got to this point, where an e-cigarette product poses such a serious risk to kids as to require urgent action. And here it is useful to review the relatively brief history of FDA regulation of tobacco. And my view is that that history shows that the emergence of JUUL and other e-cigarettes as a threat to our kids is itself a product of FDA's failure to use its regulatory authority appropriately to protect public health, and especially our kids. Change the slide, please. Thank you. So the 2009 Family Smoking Prevention and Tobacco Control Act gave FDA immediate authority to regulate certain tobacco products, cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco. But it also provided that FDA may extend its authority to other tobacco products by issuing a rule deeming those products subject to its authority. And the statute defined tobacco products broadly enough to include e-cigarettes. Well, in April of 2011, FDA announced its intention to issue a deeming regulation to extend its tobacco product authority to e-cigarettes and other products meeting the definition of tobacco product under the statute. But the agency did not issue a final deeming rule until May of 2016, 5 years later, to be effective August of 2016. During those 5 years, e-cigarettes remained unregulated at the federal level. And what happened during those 5 years? Next slide, please. Well, we know that the e-cigarette industry exploded. It is now a $5.5 billion industry. We know that thousands of varieties of flavored e-cigarettes emerged. I think we're now up to something like 15,000 flavors, additional flavors being added every month, many of them sweet fruit and candy flavors that are highly appealing to kids. And we know, as this slide indicates, e-cigarette use by young people also exploded, increasing from 1.5% of high school students in 2011 to 16% by 2015, before declining in 2016. Well, it is legitimate to ask what would have happened if FDA had issued a deeming rule years earlier, like in 2012 or 2013. Could the emergence of JUUL as a threat to our kids have been avoided? And here it's important to understand FDA's authority to regulate new tobacco products. Next slide, please. Okay. The Tobacco Control Act requires an FDA order before the marketing of any new products. And new products are defined in the statute as those commercially introduced after February 15, 2007. So you'll note there's an element of retroactivity here because the statute was passed and went into effect in 2009. Now, products introduced before that 2007 date are grandfathered and don't need to undergo review. But generally speaking, the manufacturer of any new product must show that the product is appropriate for the protection of the public health. That's the standard in the statute. There is an important exception to this. Products that are found to be substantially equivalent to a grandfathered product do not have to meet the public health standard, but that is a pathway to market that is likely not applicable to e-cigarettes because there were few e-cigarettes on the market to serve as predicate products in 2007. Well, we know that JUUL was marketed beginning in 2015. So if the deeming rule had been issued in 2012 or 2013, JUUL and many other e-cigarettes could not have been marketed without a prior FDA order establishing that they met the public health standard. And that would have involved an FDA assessment of the likely population-wide impact of the product on both users of tobacco products and non-users of those products, including an assessment of the likelihood initiation by young people. So the manufacturer of JUUL would have had to demonstrate, in order to get that pre-market order, that its features would not attract kids. But alas, the deeming rule did not become final until 2016. By that time, there were thousands of e-cigarettes on the market, including JUUL, and they had not undergone review under the public health standard. Well, how did FDA propose to address those products already on the market? Next slide, please. Okay. Well, under the deeming rule, e-cigarettes that were already on the market as of the effective date of the rule, which was August 8, 2016, could remain on the market as long as an application for a marketing order was submitted before August 2018. So that was a 2-year, what FDA called compliance period for applications to be filed. And then the deeming rule provided that those products could remain on the market generally for a maximum of 1 additional year while FDA considered the application. So that was the situation under the deeming rule as it affected products that were on the market as of the effective date of that rule. Next slide, please. But after the Trump administration came into office, there was a major change in FDA policy. In August of 2017, FDA issued a guidance for industry. And that guidance suspended product review of newly deemed e-cigarette products for 4 additional years. The products could stay on the market if an application for a marketing order was submitted by August 2022 instead of the August 2018 date in the original Deeming Rule. There were also extensions for other kinds of products like cigars. So those e-cigarette products were allowed to stay on the market without FDA review for at least 6 years and maybe more after the effective date of the Deeming Rule. And they could stay on the market until FDA ruled on the application. That wiped out the 1-year limitation period in the original Deeming Rule. And so they could stay on the market potentially indefinitely because there was no deadline for FDA to act on those applications. Thus, thousands of candy and fruit-flavored e-cigarettes will remain on the market for at least 4 more years without FDA review under this guidance. Now, the guidance only affects products that were already on the market in August of 2016. If a manufacturer seeks to introduce a new product after that date or modify its product, it must have a marketing order before it can do so. Well, what does this mean for JUUL? Well, under the Deeming Rule, putting aside for a moment the guidance that was issued last year, JUUL and other e-cigarette manufacturers would have had to submit by next month, August 2018, evidence establishing that their products meet the public health standard. And then JUUL and other products could stay on the market for a maximum of 1 additional year until August 2019, while FDA considered the application, but generally speaking, they would not be able to stay on the market beyond that point. In contrast, under the August 2017 guidance, JUUL will remain on the market until at least 2022 and perhaps beyond. Slide, please. Well, the adverse public health consequences that flow from the August 2017 guidance and the suspension of pre-market review for years to come led to the filing of a lawsuit on March 27th of this year by 6 public health and medical organizations and 5 individual practicing pediatricians against FDA, challenging the legality of that 2017 guidance. And I will briefly summarize the legal claims made in that lawsuit without going into too much technical detail. First of all, the lawsuit argues that the guidance exceeds FDA's authority under the Tobacco Control Act because the requirement of a marketing order for all new products under the statute is mandatory. FDA's decision to allow thousands of new tobacco products to remain on the market for as much as 6 years without a marketing order is an abdication of FDA's duties under the Tobacco Control Act. Second, the lawsuit argues that the guidance is arbitrary and capricious and thus violates the Administrative Procedure Act. Agencies can certainly decide to change policies, but the law requires them to give a reasoned explanation justifying the change. And one searches that August 2017 guidance in vain for anything approaching a reasoned explanation for why FDA is suspending pre-market review for years to come. And finally, the lawsuit argues that the guidance is actually equivalent to a substantive rule, and yet it was issued without giving the public an opportunity to comment as required by the Administrative Procedure Act. So there is also a procedural defect in the way FDA went about this. The lawsuit was filed in federal court in Maryland. The plaintiffs include the American Academy of Pediatrics, the Maryland chapter of AAP, 5 Maryland pediatricians, the Campaign for Tobacco-Free Kids, the American Cancer Society Cancer Action Network, the American Heart Association, the American Lung Association, and Truth Initiative. And pro bono legal help is being provided by the in-house staff at the Campaign for Tobacco-Free Kids, along with the law firm of Wilmer Hale, and the public interest law firm of Democracy Forward. Briefing on the dispositive issues in the case has begun. We actually filed our brief in support of our motion for summary judgment yesterday. So the case is moving along, and the dispositive issues will be joined, we hope, for argument in the case before too long. Slide, please. Well, what has FDA done about JUUL? Well, in April, the agency announced that it had been conducting an undercover national enforcement blitz, that's FDA's term, to crack down on the illegal sale of JUUL e-cigarettes to minors, and had actually issued 40 warning letters concerning violations to various retailers. FDA also announced that it had contacted eBay regarding its listings of JUUL products on its website, and that eBay had responded saying it was prepared to voluntarily remove those listings and agreed to implement new measures to prevent new listings of e-cigarettes. And finally, FDA tendered a request for information to JUUL, to the manufacturer of JUUL Labs, to obtain documents to enable the agency to better understand the youth appeal of these products. So it's seeking documents concerning the marketing of the product, health and behavioral effects of the product, including youth initiation, and whether certain product features appeal to certain age groups, among other documents. Its deadline for production of those documents was set for June 19th, so it has already come and gone. And I don't know what document production has actually occurred. In May, FDA issued a similar information request to 4 other e-cigarette companies selling products that share certain features with JUUL, and the features that FDA has delineated are the use of e-liquids containing nicotine salts and having high nicotine concentration, a small size affording a great concealability, and product design features that are intuitive for novice users. So these are the features that FDA is concerned about, and the features that define the companies that have received these follow-up information requests. New slide, please. Well, the question now is FDA doing enough, particularly given the dramatic increase in JUUL's market share as indicated in this graph, which is now about 68% of the market, according to the Nielsen data. And certainly, although cracking down on illegal sales of JUUL by retailers is important, it is necessary, it is hardly sufficient. The problem is not just the illegal sale of the product, the problem is the product itself. Now, FDA's information request to JUUL is designed to address the product, but given FDA's guidance establishing a policy that allows e-cigarette products like JUUL, already on the market in August of 2016, to remain on the market until 2022 without a marketing order, it is not clear what actions FDA is prepared to take based on the information it obtains from JUUL. And in addition, publicly available information indicates that new flavors of JUUL, including mango, were introduced in 2017, long after the 2016 effective date of the Deeming Rule. New slide, please. As indicated in this table of changes in both flavors and colors in the product, many of which occurred after the effective date of the Deeming Rule, and yet there's no evidence that a marketing order was issued for any of these changes. Keep in mind that even under the August 2017 guidance, these new flavored products could not legally be introduced into the market without a pre-market order. The suspension of pre-market review under the guidance only affected new products on the market as of August 2016. So it's not clear at this point whether FDA is prepared to address the issue of whether new JUUL flavored products may have been illegally introduced after the effective date of the Deeming Rule. But what is clear is that FDA, through its August 2017 guidance suspending product review, has deprived itself of a critically important tool to protect young people from highly addictive and attractive e-cigarette products like JUUL. And certainly the experience with JUUL thus far underscores the importance of the litigation brought by public health groups challenging that 2017 guidance. So thank you all for listening. I'll turn the program back to Mark.
Thank you so much, Denny. That was fantastic. It's a really important and helpful framework that highlights, I think, the importance of, at least for the foreseeable future, state and local regulation in this area. So next, I'm going to turn it over to Hudson Kingston, who's going to talk about state and local policy options.
All right, thank you both. Hi, everyone. My name is Hudson Kingston, and I'm a staff attorney here at the center. As Mark said, I'm going to be talking about state and local policy options in regulating e-cigarettes like the ones made by JUUL. While JUUL is the industry leader by sales, there are many other companies that are vying for its profits and customers. So this presentation is really about e-cigarettes with characteristics similar to JUUL. Other manufacturers of similar products and pods are pursuing the same types of promotions and practices as we'll go over today. If you'd like to hear more about what JUUL is and the impact it's been having on kids, I encourage you to go back to our archived webinar from a couple months ago and a publication we did along with that, which I'll be referencing quite a bit today. State and local governments have a lot of power to promote public health by regulating tobacco products like e-cigarettes. Some of the policies we'll be talking about today are suited for action by the states, or maybe even to the FDA in concert with state and local governments, but many of them are also appropriate for local governments to adopt. Let's open by talking about two of the big ones: price regulations and smoke-free standards. All right. So price regulations are particularly useful tools as regards to JUUL and similar products' current marketing practices. As folks on this call know, research has proven that pricing controls are one of the most effective ways to prevent sales to youth and thereby decrease youth use and access. The JUUL starter kit, which includes the devices and 4 pods, normally retails for $35 and pods cost $16 for a pack of 4, except for when they don't. As you see here, in Minnesota gas stations, JUUL starter kits are being discounted 42% and advertised right alongside buy 2 deals for chewing tobacco. And these sort of discounts and package deals make it easier for never smokers and youth to access these products easily. This is what happens without pricing controls. Here's another recent example from Missouri. You'll see that the prices are still lower than the normal sticker price, and both the basic kit and the pack of 4 pods are being discounted. If you look at the fine print, you'll also see JUUL's signs are highlighting the flavors and the fact that it's not for sale to minors, not anything like a Tobacco 21 standard. These practices are coordinated and similar across many states. Pricing deals are also available online. This is JUUL's website. Over the internet, JUUL will provide you with promotions and discounts if you sign up for their automatic online sales. And so, for example, they'll give you an every 6th pod pack for free if you register for auto ship. This is a pretty common marketing technique for tobacco industry, and e-cigarettes have proven to be no different. So what policies are available? These pricing options are from the report we recently put out called JUUL and the Guinea Pig Generation. And the policy options here are to prohibit free or cheap samples, enact laws that prohibit discounting of these products and the redemption of coupons or deals, including the buy 1 get 1s or buy 5 get 1s that JUUL's doing on its internet or on its website. And as it says in the last bullet, one big pricing power that states have is the power to tax in order to protect health and increase tax revenues. We'll cover that a bit more in the next batch of slides. At the outset, it's worth remembering that the World Health Organization has determined that the best practices include a tax on tobacco products up to 70% of the price of those products. There's not just one tax policy that works for all states, but taxation is a powerful tool that the states can use and might not be using to the fullest. All right, so in the world of taxation, we have this recent case from Pennsylvania where the court found that the state's Department of Revenue was well within its rights to apply the state's 40% tobacco product sales tax on e-cigarettes and e-liquids. The court rejected arguments that some e-liquids did not contain nicotine, and some nicotine in e-liquids might come from sources other than tobacco, and found that agency's interpretation of the law survived rational basis review. Fans of our webinars will know that rational basis is a constitutional test that nearly always leads to the government getting deference from a court. So in this case, it could still be appealed. It's at an appeals court level. But the lesson to take away is that the rational basis test here applied to the agency's interpretation of the words tobacco products is a pretty clear sign that agencies are within their rights to regulate and tax e-cigarettes and e-liquids. Another recent decision, hot off the presses, that cannot be appealed comes from the US Supreme Court. This one is from South Dakota versus Wayfair. And in it, the Supreme Court decided to get rid of a physical presence test, which only allowed states to tax internet sellers if they had sufficient presence in the state. They determined that it was inconsistent with how online shopping works and was unfair to states and other retailers who are paying state taxes. And as a result of this recent case, states now have full authority to apply their taxes to internet sales and expect online sellers to abide by their tax laws. This becomes important because when you have that sort of a power of taxation, you can use things like tax stamps. Now, tax stamps are used generally on cigarettes right now. They've been at it for a long time. This example is from 1907. Tax stamps have been around, and 47 states have been using them to collect taxes and also to aid researchers in studying smuggling from one jurisdiction to another. Almost all states have them. And in fact, 3 states have implemented what are called high-tech tax stamps: California, Massachusetts, and Michigan. They're a valuable tool, both for tax collection and in helping the regulators to understand the tobacco market that exists in their state. By taking this high-tech tax stamp model that is currently used for cigarettes and applying it not only to e-cigarettes and e-liquids sold at retailers, but also to internet sellers, a state could make a huge step forward in understanding how the state's e-cigarette market is working. For states that are not considering a prohibition on internet sales, a strong tax policy, including high-tech tax stamps that indicate the origins of the product and other details about its manufacturing, could nonetheless help in addressing both youth access and state tax collection. And it's important to note that the CDC determined that 2 of the states have already reaped hundreds of millions of dollars by implementing this technology without adding any new taxes at all. They just increased revenues well beyond the cost of implementation and enforcement. And that could also prove true for e-cigarettes if states implemented and enforced strong standards. Beyond pricing regulations and taxes, we have the ever important smoke and tobacco-free standards. Local governments should look to updating their smoke-free standards to be comprehensive, both in the places they cover and the products that are prohibited. Treating e-cigarettes the same as smoking not only improves public health, but it also makes enforcement easier for police and private parties who are required to inform violators about the law. Many states are still in the process of doing this, and local governments and schools have the opportunity to act more quickly and get standards passed that might encourage states to take action in a similar respect. As we learned in our last webinar, much of the concern about JUUL is coming from our schools, where educators are having a hard time dealing with the rapid uptick of youth use of these new tobacco products that are easily concealed and highly addictive. At a minimum, it would be useful for localities to look at their tobacco-free schools policies and smoke-free ordinances to be sure that using these devices and possessing them in schools is forbidden, similarly to how smoking or having tobacco products is already covered. And just one a few more points here. This photo is actually from our neighbors to the north, so I thought everyone would like to learn the word vaping in French. But additionally, there's two big things to remember about updating these policies. The sales and pricing restrictions that we're going to be talking about today are the main tools in controlling youth access. Punishing youth too harshly for possession or use has a limited ability to change behavior and could potentially make it harder for youth to get the help that they need to address their reliance on nicotine. It has been widely, and number two, it has been widely reported that JUUL is reaching out to schools in order to provide them services such as educational materials for students that are caught using JUULs. In many states, taking such assistance from a tobacco company is against existing policies, owing to lessons learned from when cigarette companies made similar offers in the past. It's important for educators and local leaders to update their policies to include e-cigarettes, but also be mindful of these equity issues. Okay, so now moving into a big part of the options that folks have at the local level, and also from our report, JUUL and the Guinea Pig Generation, we're going to talk about sales restrictions. This is a wide variety of policy options, and our list here and in the following discussion will begin with some of the better known options and move along to some that you maybe haven't heard about. Up here on the screen right now, we have Tobacco 21, limits on the ability of certain retailers to sell tobacco products, limiting the sales of these products to tobacco only or adult only or 21 only even retailers. And then also flavor restrictions, which we'll definitely get into. And then continuing, because this is a long list, there are also the options of sales restrictions based on the nicotine content of the product, internet sales restrictions, and then for places that aren't ready to do the full internet sales restriction, internet sales policies to strengthen compliance and controls. Now let's quickly talk about Tobacco 21, everyone's favorite. T21 is a policy that currently is working in 5 states and at the local level in hundreds of places across 20 states. It is similar to the minimum age laws that all states already have for tobacco products and alcohol, and it pairs well with other controls, such as restricting sales to retailers that don't admit teenagers. It also could be paired with flavor restrictions or other sales controls. To go quickly to flavors here, San Francisco is JUUL's headquarters and also has the claim to fame of being the originator of such amazing flavors as chicken teriyaki, rice-a-roni. Also, this year, San Francisco passed one of the most comprehensive flavor restrictions in the nation when it passed an ordinance which was later overwhelmingly approved by voters, stopping the sale of flavored tobacco products at all retailers inside the city of San Francisco. So consumers in San Francisco will not be confronted with flavored tobacco products, including menthol cigarettes, at licensed retailers going forward. But for those who are wondering what this kind of flavor restriction looks like in practice, we have some examples from Minnesota. This is from Duluth, Minnesota, and this photo is from March, showing JUUL and its competitors on sale at a gas station right next to the candy. Like San Francisco, Duluth passed a strong flavor restriction that started on June 12th. And this store and others that were not tobacco only and adult only retailers had to stop selling flavored products, including menthol. Let's see what that looked like so far. So another one of the retailers in Duluth, this change made Duluth's in-store sales of JUUL and similar products quite different. While the stores have continued to sell JUULs with Virginia tobacco flavor, they have also removed countertop displays and replaced them, in this case, with energy drinks. When asked, they were still selling the JUUL packs for $25, so the products might still be out of eyesight, but they are available and currently discounted. Another example from Duluth, Minnesota, where the display case for cigarettes was replaced with some lanyards. On-site inspection also noted a decrease of advertising from JUUL and similar products, but this is fairly anecdotal evidence right now. If you look in the after photo on the right, you'll still also see that there's a Views case on the counter, but is not nearly as visible as the display that was up before the prohibition went into effect. Now, less anecdotally, a recent study in the Twin Cities looked at their flavor restrictions, which are similar to Duluth with some limits that flavored products can only be sold in adult-only stores. And they found that compliance was pretty strong in gas stations and convenience stores, and flavors were much less available. But if your state or locality has already done that with T21 and flavors, there are some other options. So going to the great state of Utah, it is difficult, if not impossible, to cover everything that's going on in Utah in this regulation, but feel free to write down the administrative rule number and Google it to see everything. We're going to cover some of the things in Utah and then also internet sales restrictions. In 2016, Utah passed a comprehensive law that called for regulators to make regulations about e-cigarette content and packaging. The Utah Department of Health established some sales restrictions. And for anyone who's counting, JUUL's e-liquid content is roughly 59 milligrams of nicotine per milliliter. And the sales restriction in Utah that's there in sort of small type is for 24 milligrams per milliliter. That means that JUUL is more than twice as strong as Utah's sales restriction. Additionally, Utah's law required, and the agency wrote, regulations on the labeling of e-cigarettes with warning labels. So why is Utah's law not functionally prohibiting sales of high nicotine pod style e-cigarettes? And why haven't you heard about these warning labels? Well, the Utah legislature included an exception that is important to these types of e-cigarettes. The standards covering e-cigarette sales and labeling do not cover pod type cigarettes where the manufacturer doesn't intend for the top pod to be opened. The exceptions right here, since they are, quote, manufacturer sealed electronic cigarette substances, unquote, they are accepted from all of the regulations. And this is really a missed opportunity for Utah, leaving all of the pod type stronger products on the market without the protections of the department's public health-based standards. But for those who are not ready to go all the way to that type of sales restriction, there's still the possibility of having a restriction on internet sales. About a dozen states have restricted the shipping and mailing of tobacco products directly to consumers, and many of these laws apply to e-cigarettes. Some standards are stronger or more explicit than others. Maine and Washington both have standout laws in that they cover all tobacco products and also discuss enforcement options for the state in pretty good detail. But they are not the only states to do it, and certainly no one state model will fit all states. It's important to always check with what's already going on in your laws and match things up more correctly. There is another state that notably has had a prohibition on internet sales to consumers for much longer than these two, for decades really. And for anyone who's good at geography could probably guess, but that's right, the state is Arkansas. Arkansas has had a law in the book since 1977 that prohibits internet sales of tobacco products. And you might ask, how is that possible? Well, the law on tobacco product sales defines a retailer to indicate that they can only be making over-the-counter sales to retail or to consumers at retail. And as a result, the Supreme Court of Arkansas in 2004 determined that the over-the-counter requirement meant that the legislature intended for all retailers to have a physical presence in the state. This, the court noted, and the legislature put in its findings, is justified based on the legislature's intention of keeping tobacco products out of the hands of minors. The court noted that the identity and age verification procedures for mailed tobacco products didn't work well enough, and that further justified the state's position prohibiting mailed sales, including internet sales. This is just a quote from the concurrence, and it's the concurrence found that it was of singular importance to find, as the court did, to prevent youth access to tobacco products. And the law since this case has been updated to include e-cigarettes and has not taken out the words over the counter. So functionally, this is a prohibition on internet sales of e-cigarettes. More options were given in JUUL and the guinea pig generation, which we're going to have to hit on quickly. These include enforcement of consumer protection standards and limiting some types of marketing. In terms of the misleading claims, it's important to think back to FDA's authority to approve or deny tobacco products' claims of modified risk or reduced risk of their product. No e-cigarette has proven to the FDA that they are safer than an existing tobacco product, and therefore no e-cigarette can currently be marketed as a reduced risk product. While this concept finds its way onto vaping blogs quite a bit, it isn't backed up by evidence that has convinced the FDA. So state and local enforcement authorities could be on the lookout for those sorts of statements, which currently have not been approved by the government and have to undergo that sort of review. Other jurisdictions that are interested in product transparency might also look to ingredient disclosures or lab testing. And just before we move on from marketing, I wanted to say it's very important to keep an eye on what the First Amendment allows and work with your legal counsel to make sure that those restrictions, if you're doing them, are consistent with the law. Just very generally, it's important to keep these 5 points in mind when crafting any new policy, and the center's here and happy to provide technical legal assistance to help you achieve these goals and review any ordinance or other language of a policy you might be interested in. It's just very helpful both for enforcement, but also for just general people's understanding of the law to keep things well-defined, concise, and clear. And then also enforcement and implementation before enforcement actually needs to be thought of and worked out ahead of time. And just to sort of plug our publications once more, much of the information in this presentation and more comes from our recent publication, JUUL and the Guinea Pig Generation. And I would also like to remind you of 2 other helpful publications we prepared on these topics. Including Regulating Electronic Cigarettes and Similar Devices from 2017, and a little bit older one, E-Cigarettes and Other Tobacco Products Online, Preventing Sales to Kids, which is full of helpful information. With that, I see that my time is probably up, and I would be happy to send it back to Mark for any questions.
Great. Thank you very much, Hudson. So we have gotten quite a few questions here, and I guess I should start off by saying that if we don't have an opportunity to answer your question directly, I would encourage you to contact us at the email address, thepublichealthlawcenter@mitchellhamlin.edu, and we can talk to you individually to help answer your specific question. But we do have a lot of questions, as I mentioned, so I want to get as many. We have about 10 minutes left, so let's try to get as many in as we possibly can. The first one is, I think, more for Denny. There's a question about, let's see, about JUUL and I guess other probably e-cigarette companies that are incentivizing sharing of information about these products by offering people a free sample or a free product, and what the FDA under the Tobacco Control Act is that prohibited or allowed?
The prohibition on free samples applies to these e-cigarette products through the Deeming Rule. The statute is passed in 2009, applied various marketing restrictions to the products that were like cigarettes that were regulated from the beginning, and the Deeming Rule extended some but not all of those marketing restrictions to the deemed products like e-cigarettes and cigars. But free samples is one of the marketing restrictions that was extended, so there should be no free sampling going on.
Denny. This one, I think probably both of you might have some thoughts on it, but maybe I'll start off with Hudson. There was a question on best practices for taxing e-cigarettes, both in terms of, I guess, the breadth of the tax, whether it includes nicotine and non-nicotine products, devices themselves, and also how the tax should be calculated and administered, whether it should be based on the value of the product or the volume or the amount of nicotine in the product. So I'll let Hudson take that one first, and Denny, if you have thoughts, feel free to add them as well.
All right. Okay, so that's a big question and a big answer. So first I would say very much to whoever asked this, check out our publication regulating electronic cigarettes and similar devices. I think we cover this pretty thoroughly in there. But just answering on the spot, it seems important to highlight that there isn't one size fits all for all states, but it's important to have a high enough tax standard to get up to both a public health promoting tax level and to reduce youth access. So the World Health Organization puts that at 70%. I think that a lot of states have been doing this as a value-based tax, a percentage of what the product is selling for. And it's just important to craft those or pair them with prohibitions on discounting or free giveaways, because obviously a value-based tax is useless if they're getting the device for free. Cigarettes are done in a per unit manner, and that has worked really well along with tax stamps. So, any one of these options would work, but the overall percentage increase should be around 70% of the value of the product. Denny, do you have anything else on that?
No, that was a very, very complete answer. Taxation of e-cigarettes raises all kinds of interesting policy issues. And much is determined by, the public health assessment of these products. There are many who believe that these products should be taxed at a lower rate than combustible products because they are less hazardous, and we want to encourage smokers to switch to them. But then there is the problem of youth access. We know that high prices are a huge disincentive for kids to begin initiating tobacco products. So there are tough policy issues that are inherent in these tax questions, and I think Hudson covered it very, very well.
Great, thanks to you both. And I do think this is probably one of the more complicated questions, and it's one I don't think we have a clear answer to yet. We're still learning as more states are finally taxing e-cigarettes, which has been kind of a long time coming. Another question for Denny related to Commissioner Gottlieb's announcement last year regarding reduced nicotine levels and whether this will have any effect on JUUL or other e-cigarettes.
Well, as folks know, Commissioner Gottlieb announced a very ambitious plan, the cornerstone of which is to move forward towards a product standard that would reduce nicotine in cigarettes to non-addictive or minimally addictive levels, which has just enormous potential implications for public health. It is a very exciting concept. And one kind of open issue is, the extent to which it helps or hurts such a policy to have alternative nicotine products available, like e-cigarettes, that sort of provide an alternative for those who are addicted to cigarettes and are then deprived of their highly addictive nicotine cigarettes to have a place for them to go. That's one reason why the commissioner has also talked about being able to make some judgments about these e-cigarette products and the degree to which they may be able to actually assist in the implementation of a reduction in nicotine in cigarettes and the movement of cigarette smokers to less dangerous products. From our perspective, it remains very important to be able to determine just what e-cigarette products actually do help smokers quit versus products that simply attract kids or attract dual use and have very little public health benefit. And the whole process of pre-market review is designed to get at answers to those questions for individual products. And so that's one of the consequences of the suspension of pre-market review of these products for years to come, is that we are not getting those answers about individual products that could be very helpful.
Excellent. That's great. Thank you very much, Denny. We also had a question about local or state tobacco retail licensing laws and whether those are a good framework under which many of these policies could be established. So I'll ask Hudson to mention.
Yeah, and I that may have been an omission on my part. I mean, I'd say that most, if not all, of the policies I went through are best done with a strong licensing policy. I mean, perhaps not the internet sales, but in Arkansas, it was the licensing law that they used to forbid internet sales. So in that case, even that was a licensing control. You know, pricing controls and sales restrictions and all of these things are implemented at the retail sales level, and having licenses for retailers gives the retailers a big incentive to keep that license and still maintain their rights under that license. If they're found in violation, you know, you can issue fines, but taking away their license is a very effective deterrent to violations. So it's a central part, especially of local control.
Great, thank you. And I think we probably have just time for one more question. And again, I would encourage you to contact us because I know there have been a lot more out there that we have not been able to get to. One last question I think that you probably each could talk a little bit about is regarding flavor restrictions, which is there's been a lot of interest in those. And we know San Francisco banned the sale of all flavored tobacco products. So I guess the question is twofold. One is there a sense that the FDA might extend its flavor restriction to include e-cigarettes in the near future? And then two, and I guess that's probably more for Denny, and then I think for Hudson, there have been some questions about litigation at the local level, I guess, regarding flavor restrictions. So maybe Denny, if you want to take the first stab at it.
Yes, I mean, one of the announcements that Commissioner Gottlieb made last year was that he wanted the agency to take another look at the whole question of flavored tobacco products and kids. To that end, FDA has published what it calls an advance notice of proposed rulemaking, seeking public comment on just those issues. Actually, the comment period is for that docket is closing this month. I believe it's closing on the 19th. So there is still some time for folks to weigh in on this. It's an enormously important issue because the science is very, very strong that flavored products do increase the prevalence of youth and young adult use of tobacco products. Clearly, flavors have been a factor in the meteoric rise in popularity of these products with kids. Flavored cigars are a huge factor in attracting kids to cigars. Now we have more male high school students smoking cigars than cigarettes, and it's in large part due to the emergence of flavored cigars after flavored cigarettes were prohibited by the Tobacco Control Act. So I urge everyone to weigh in, submit your comments in this docket. They don't have to be long, they don't have to be sophisticated, but let the FDA know what you think.
Thanks, Denny.
And then this is Hudson real quick. So there has been litigation about localities with flavor restrictions, specifically sales restrictions. And there were some big cases coming out of New York City and Providence, Rhode Island. And as a result of that, we know from the Second Circuit Federal Court of Appeals and the First, I believe, that as long as the locality stays in their lane and does a flavor restriction as a sales restriction, they're well within their rights reserved under federal law. And it's been a useful tool and one that the courts have said the local governments have the power to do.
Great. Thank you to our panelists. We really appreciate taking the time to join us today, and for everybody who joined us in viewing the webinar. Again, please let us know if you have any follow-up questions. Our information is on the screen right now. Hope you all have a wonderful afternoon. Thanks.